Thank you, Mr. Chair. Commissioner, on September 19th, 2025, the Globe and Mail reported that a real estate executive, a lobbyist, and a banker, who all happen to very conveniently be Liberal insiders, held an exclusive reception for Liberal MPs and cabinet ministers during the recent Liberal National Caucus retreat in Edmonton, where Liberal MPs and cabinet ministers were invited for a beverage to discuss politics. Now, to be clear, lobbying rules require lobbyists to report a meeting with public office holders, even if they are oral and arranged, correct?
Yes.
And under the Lobbying Act, reportable subjects include communicating with a public office holder regarding the development of any policy or program of the Government of Canada, the awarding of grants, contributions, or other financial benefits, the awarding of contracts, the making or amendment of any regulation or introduction of any bill. It's pretty broad. Have I got it right?
Yes.
Okay. Now, with respect to this reception, has any return disclosing communications with one or more public office holder on a reportable subject been filed with your office?
I don't believe currently, but they technically have until October 15th to impose any monthly communication report. So they have to do it by the 15th of the following month of when the communication would have occurred, if there was a communication during that period that would meet the definition that you've set out.
Now, can you understand why I and a lot of Canadians would really have a tough time believing that a reportable subject would not have come up in that context, with Liberal MPs, cabinet ministers being invited by a real estate executive, lobbyist, and banker to discuss politics?
So, well, the thing I have to say here is I've looked at that article and I've gone through it, and most of the people that were involved in this are not registered lobbyists. So that's the first element. The second element, if there was a registrable subject discussed, it would have to be on behalf of their employer or a client. So that's a second step before they would need to register. Having said that, if you don't mind letting me finish, when these types of events occur and the people that are not the ones that are organizing it are not the actually registered lobbyists, we do have a section in the Code of Conduct, 4.3, that says very clearly, you should not be lobbying people that possibly have a sense of obligation towards you. And some of the examples in there are because of gifts and hospitality that go beyond the rules. And I put that in there because, and that's another conversation we'll have during the ledge review, I do believe there needs to be corporate accountability, not just lobbyists' personal responsibility and accountability under the Act and the Code. So,
speak about a sense of obligation,
yes.
Also in the Code, that encompasses political work. Is that right?
I do have a section specifically on political work, yes.
And here we have 3 individuals who just happen to sit on the Liberal Party executive.
And because of that role, it's maybe they're not lobbying, though. I don't know what occurred during that meeting,
yes,
but for sure, if there are lobbying, then there's possibly some issues there, yes.
If there was technical compliance with the Act by the organizers of this reception, if you're in their position, why would you hire someone to lobby cabinet ministers to talk about a reportable matter, a matter that would otherwise be reportable, if you can host a reception, buy drinks, and use your position of influence to spend time with a cabinet minister or an MP to make your case because you're a Liberal insider? I mean, why would you pay someone when you can go directly and do what a lobbyist would do, but you just have a lot more access and a lot more influence? That seems to me to be, at least on the surface, what happened here.
But facts matter, right? So it really will depend on whether these individuals are there to represent anybody, and that's how the Lobbying Act applies and it works right now.
But it's certainly, there's a lot of smoke there, isn't there, on the surface? And even putting aside the specifics of this event, there's a major loophole in the act for the scenario that I just described.
I do agree that we need to have that conversation about corporate accountability and responsibility. Yes.
Thank you, Ms. Belanger. Thank you, Mr. Cooper.
Thank you, Chair. Thank you for being with us, and hello. For those who are listening, lobbying is an activity communicating with elected officials in order to influence their decisions or legislation to benefit a particular group. That is the definition. And this is something that I repeat when I meet people and people who have less and less trust in our institutions. Do you feel that you are supported, sufficiently supported? And earlier you stated that we used to be leaders internationally, but now we are seeing a decline. I think since 2016, 2017, since there was supposed to be a review, the legislation in BC was adopted in 2020. So 2012, we know what the situation was. In 2016, 2017, things started to decline. Well, there were a lot of legislation being adopted throughout the world that could be interesting to consider here. We're following behind. And why has it not been a priority for the government to ensure that lobbyists follow the rules? And another question, we're talking about 32 hours and the 20%, and now you're seeking 8. Is it because there are more and more lobbyists? I have seen an increase, but also in 2024, for example, there were 22 lobby days, Hill days, and there were no registrations. Why are we now finding ourselves in a world where there are more and more lobbyists? Is it because people are realizing that paying somebody's lunch on this side works? Well, I hope not, because there are rules on paying for lunch on this side, so hopefully there shouldn't be too many of those. I think lobbying's a good thing. It is important for all of you. You have to make decisions for Canadians, and you need to know what their concerns are and have that information. So we can't, and I know that people roll their eyes when we talk about lobbying, but it's a good thing, but it needs to be transparent and ethical. And now we had an issue with transparency. I did what I could for the ethics of it, but there's a problem with transparency. I see newspaper articles. I do these investigations, and proving that 32 hours is almost impossible. Looking at all of these meetings that are happening without registration, that's not good. It's a bit like the Wild West. The structure isn't solid enough, and as you mentioned, there are no consequences, or the consequences don't go far enough. Now, regarding the number of offenses that you sent to the RCMP and the number that come back to you, can you share that? That come back to me? Well, I've sent 18 since I became commissioner. So 18 in 7.5 years. 2 accusations were made. 2 files where there were talks, and you were saying about 10 per week that aren't following the rules. So is it that 18 of them had significant problems, or is it 10 per week? For those 10, it's registering. They're registering, but they're a few years too late, or I don't investigate. I ask them why they were late. I ask them to do the training, and I investigate if there is no registration. There's clearly lobbying happening. I come to see you as a witness, and then I see whether or not they meet the threshold and if it needs to be sent to the RCMP. As with access to information and privacy, the commissioners need more powers to ensure accountability for government and for those interacting with government. People who do lobbying and who aren't registered don't need to be registered. The issue is with the legislation and the interpretation of those 32 hours. So that is a significant problem. We need to be registered. Transparency is essential for democracy. Thank you.